Hello, Newcastle. I'm in San Jose at the NVIDIA AI conference. I'm really sorry that I can't be with you, and I hope that you've been having a really informative and enjoyable morning with your colleagues and learning from our very learned speakers. So I've written a paper that should be within your materials called A World Without Lawyers: Is Automated Decision Making the Future? I'm not going to speak to that paper. It's there in your papers, but the conclusion may surprise you. And that paper is actually due to be published in the Law Society Journal in the next few months. I'm not sure exactly when, but they've told me that it will be published. So the conclusion in that paper may surprise you. I do not say that the world can survive without lawyers at all, but query really what the role of the lawyer will be. So at the time of recording, DeepSeek has been on the lips of many people, and because I started my legal tech firm almost a year ago now, lots of people have been messaging me and saying to me, what does DeepSeek mean to you? What does DeepSeek mean to you? And I think a lot of people don't actually appreciate the significance of DeepSeek. Yes, when it was first released, it was the #1 most downloaded app in America on the day, a couple of weeks ago, I think on a Monday, and I think the DeepSeek servers crashed or something went wrong and they were having trouble onboarding new users. But what is really exciting about DeepSeek is that it managed to train a reasoned model on a shoestring budget, supposedly $5.6 million US, whereas OpenAI cost them billions of dollars to do the same thing. Or 1 billion, several billion dollars. And what's also exciting is that OpenAI created their reasoning models using a lot of computer power, tens and tens and tens of thousands of computer chips. I don't know how many, but using the NVIDIA's best AI chips. But what you may not appreciate, and I didn't appreciate this until yesterday myself, that NVIDIA has never stopped supplying chips to China. What they did was every time America put a ban on the types of chips that they could export to China, they developed a slightly lower level chip, which they then supplied to the Chinese market while still on its face complying with the bans that had been imposed upon them by the American government. And while the American government said that NVIDIA was not complying with the spirit of the ban, Jensen Huang has come out and said that, he is still committed to the Chinese market. So the significance of this is that DeepSeek and the owner of DeepSeek was actually started off as having a hedge fund and algorithmic trading. He had amassed 10,000 of these NVIDIA chips, not the top level NVIDIA chips, a slightly lower level NVIDIA chip. And in their research paper, which they published after they released their reasoned model, they explained exactly how it was they came to distill their own reasoning model. And supposedly what they used was only about 2,000 chips. The numbers seem to vary. Sometimes people say it was 2,000 computer chips. Some people say it's 10,000 because that's what the owner of DeepSeek says he had, and other people suggest it was up to 50,000. We don't really know. But what the DeepSeek research paper says is that it was a very small number of chips and it wasn't the highest level NVIDIA chips. And they managed to do this on a shoestring budget of $5.6 million. Now, what this means and why it's so exciting is that not only did they publish a paper which explained how they did it, and they revealed all of their training algorithms, they also released all of their code on a free-to-use license basis, the MIT license, which was free. And so that what we did when the moment actually the code was released, we incorporated it into our model and we tested it, and it did well. It doesn't read law very well, and I'll come to that later on, but on a reasoning basis, it did very well, and it was doing better than OpenAI's O1 reasoning model. But what the great thing is that once that happened, Sam Altman came out and he said that, well, maybe we shouldn't have been so conservative in the way we released all of our models, because you'll recall that 2 years ago, or more than 2 years ago now, that when ChatGPT first released, it released this ChatGPT 3 model, which wasn't very good. And very shortly after, they released this ChatGPT 4 model. It did that not because the ChatGPT 4 model was not available at the time, but they were worried that the world would not be able to cope with the ChatGPT 4. So it did it in a staggered basis. So when DeepSeek released this model, Sam Altman came out and said, I've got other models that are going to come out. And he did. Very shortly after, OpenAI released the ChatGPT o3 model. And that's a reasoning model that has formed the basis of their deep research. And what's so great about it is that it's cheaper. It's cheaper and better than the o1 model. And I think we can thank DeepSeek for this development. So, for example, the o1 model would have cost my AI about $4 US for every single complex query you give us. And this is significant because in any interaction or exchange between the user and the MyAI model, you would expect hundreds of questions, if not thousands, depending on the heaviness of the use by the user per month. And this would have cost us a lot of money, and we would have had to restrict the number of questions that you could have using the o1 model on your subscription. So what DeepSeek did was, when they released the model, we incorporated it into our legal research tool. The equivalent question would have cost us only $1 instead of the $4. These are US dollars. $1 per question instead of $4. But now the o3, OpenAI has released this o3 model, and it's cheaper than the o1 model, and it's better. And so we have also incorporated that into our model because we're in the demo stage. So at this stage, we have our own various models, language models, so that in beta testing mode, the tester can see which language model actually produces a better answer. So that's very exciting. And so for the next 10 minutes or so, I just wanted to explain to you why it is that these language models are not appropriate for use as a legal research tool. Well, basically, it's simply because they haven't been developed for use as a legal research tool. They're just an element that should be used in the development of any legal research tool. Because in my experience, and I have been feeding a lot of cases into these language models, they can't read the law. The more complex the case, the more legalese that is used in the judgment or a legal publication, the LLM simply cannot cope. Let me give you an example. Yesterday, I fed into ChatGPT the 178-page judgment of the full federal court in Allianz Australia and the Uniting Church. That's the case where the Knox Grammar School and the Uniting Church, or in effect the Uniting Church, were seeking indemnity under its insurance policy for all the historical abuse cases. I uploaded that case and I asked ChatGPT to summarize the issues for me, and I asked it to bear in mind the various different judgments in the case because I wanted to know what each judge was saying. So ChatGPT came back. It didn't take very long to read. It came back and it told me that it was a decision by majority, and that the majority judgments were Justice Darrington and Justice Colvin, and that Justice McAvoy was in the minority. It then summarized the issues that the majority had considered, and it pretty much got it right. It did pick up the key issues, and then it told me what the minority judge had said, Justice McAvoy. And that's completely wrong because the decision was unanimous. It was handed down in two separate judgments. We had the single judgment of Justice Darrington, and then there was a joint judgment between Justice Colvin and Justice McAvoy. But everyone agreed that the appeal should be allowed and that Allianz did not have to indemnify the Uniting Church for their historical sexual abuse claims. So I told the LLM. I smacked it good and hard, and I said, you've got it completely wrong. It was not a decision by majority. It was a unanimous decision, and get it right. And so it apologized to me. It likes to apologize because the LLM seems to have been trained to never disappoint anyone. And I think this could be part of the reason why it hallucinates, because even when it doesn't know the answer, it doesn't want to disappoint you, so it gives you an answer. And sometimes it just has to make it up. So it came back and it said, you're quite right. It was a decision, a unanimous decision, and it was actually, it said that the appeal had been dismissed. It said that the Uniting Church was entitled to indemnity under the insurance policies. That was completely wrong. And that is an example of hallucination. So I have found that it's very dangerous, and I don't understand why. Well, I do understand why people, lawyers, both in Australia and overseas, rely on these LLMs to do their legal work for them, because as we know, being a lawyer is so burdensome. There's so many documents for us to go through. There's so many cases for us to keep on top of, that if a tool like that comes around and it seems to be giving you the correct answer, and if it is giving you the correct answer, it's alleviating your burden by so much that you want to believe that it is giving you the truth, but it's not, because an LLM has never been developed to be a legal tool in itself. And if you have a look at all the research, etc., and all the testing that's being done on the LLMs to see how they're performing, it's never benchmarked against the law. It's only benchmarked against mathematics, physics, coding, etc. So you have to be very careful as to you have to be very careful not to rely upon LLMs by themselves to let you do your legal work, because it was never intended to be used as a legal tool, but merely as a component in the development of a legal tool for lawyers. And in developing that legal tool, any developer would have to grapple with several issues. One, that you have to train that that LLM to be able to read the law, because at the moment it cannot read the law. You have to grapple with privacy issues, and that is what is freaking out a lot of the courts and law firms, etc. Because if you are uploading your documents into the LLM, then it forms part of the general materials that OpenAI, for example, can use to train the rest of its language models and to train its reasoning, etc. So you have to be worried about the privacy of your documents, and you have to be worried about the fact that it's simply not intended to be used as a legal tool. So there is a fear. And I went to the AILA conference, the Australian Insurance Law Association conference last year, and also I think the Professional Indemnity Group conference last year. And surveys were done of the audience, and there was a big fear in the audience about job displacement. And I think the fact is that there will be lots of job displacements. I don't know to what extent. I think it's quite clear to me that the expert lawyer will always be needed, because it's not simply a case of going to law school and coming out fully formed and an expert lawyer. You need lots of practice, and you need experience to be able to work out, at least from the point of view of a barrister, what arguments you should run, what arguments you shouldn't run, how the courts will view your arguments, etc., and which ones are more likely to succeed than not. So experience like that always counts for a lot. But if you have a legal research tool like the one that we're about to put out, which we aim to answer all of your legal questions, and how we do this is that we have 5 to 6 different layers of LLMs, and we also have a few robots. So what we do is that you can upload your own documents into our system. It will be in your own dedicated server. It will be encrypted, and only you can read it. We can't read it unless you give us the encryption key. We have our own proprietary database of all the publicly available cases and legislation. Everything has been chunked, which means that we know where every line of text comes from, And then we also have a curated list of websites. I mean, currently the count is of 165 websites that we have told our agent robot that it can go into and search, so that when you ask us a question, simultaneously the robots are going out into these 3 databases doing their searches. The searches are coming back. We have a reasoning algorithm and a ranking algorithm so that our model knows that high court cases are the most important, and then intermediate appellate courts, etc. The answers are coming back, and everything is being ordered and reordered the whole time as the answers are coming back. And then our reasoning algorithms and everything is going into action. At the end of it all, we give you an answer. And that answer is transparent. We have the propositions are reduced to first principles. It's footnoted and hyperlinked to the pinpoint reference in our own vector database. And at the same time, we have told you, we will tell you, that you can also go to third-party websites to get these cases. So for example, OSLI, etc. So in this way, we have managed to reduce the risk of hallucination to almost zero because of the way we have set up our whole system and the fact that we know where everything comes from. And then we've cross-checked it against external websites so we can tell you where else you can go to get these cases. So at the same time, as a side project, because this is how this whole project first started, because I wanted perfect memory, I have read, I don't know, I'm sure at least 100,000 cases in my career, but I can't remember them all. And I've done so many advice, etc. I can't remember them all, that I went to my co-founder, Fred Almeida, and I said, I just want essentially perfect memory. I want to have instant recall of all the cases I've read, everything I've worked on, etc. And this is a side project that Fred is working on, and it's based upon, well, we were already doing it before Google published their research paper on long context memory. For them, it's called the Titan project, and what they're trying to do there is to emulate human memory. And so what we're trying to do is to deliver exactly what it is that I wanted for our model to be able to remember every single interaction that you've ever had with it, every single document that you have ever uploaded into it, and hold it all in memory, so that when you ask it a question, it has all that background knowledge when it answers the questions that you give. And so that is basically like the perfect human being, isn't it? The perfect lawyer. And if you have those capabilities, and we have our reasoning models, we have our long context memory, then if we pull all that off, then superintelligence is really just around the corner, because it's not going to take us, well, Fred doesn't think it's not going to take us more, I would say, more than a couple of years to be able to, or possibly shorter, to be able to get all this working and to deliver this to you. And I think I know the reason why I wanted this is because being a barrister can be such a drudgery. We have to be reading so many documents, be on top of so many cases, and there's just so much data that is not possible for one human being to have all that in their head. And I wanted a tool to be able to help me have all that information at the tip of my fingers and to reduce the drudgery and the burden of being a barrister. So with all that, then as an expert lawyer, with all that information at the tips, it just helps you do higher level work so that you can spend more time working on strategy and working out how you want to present your case and what arguments, and you would know, because of the way we've set up our model, we know, for example, you can search how a particular judge handles certain issues, what kind of evidence that particular judge is more likely to accept than not, how that particular judge reasons, etc. And so all that information is at your tips, and it's there delivered to you within seconds, so that at the end of the day, this can only make that experienced lawyer an even better lawyer. But what I haven't been able to answer is, what of the lower level lawyer, and what about the law student? Because in order to get deep knowledge and deep understanding of any subject matter, you have to put in the work. I don't think there's any two ways about it. For you to really understand how everything links together and how things really work, the fundamental principles in law, I think you have to do the work. You have to read the cases. You have to get on top of it all. But what happens if you no longer have to do that and the AI does that for you? How will that actually impact upon your development as a lawyer? And I haven't been able to answer that. And so that's a question for all of us to ponder. But it would be a mistake to think that superintelligence is not around the corner and that it's not going to affect how all of us work. And to ignore it would be to be left behind. So I'll leave all these thoughts with you, and I hope that you enjoy the rest of your conference. I'm told that it's a shame that I'm not here to answer your questions because you probably do have a lot of questions. But if you do, just feel free to email them to me at lena.chan@selbornechambers.com.au and I'll try and answer all of them.